Welcome back. Now, in our last lecture, we talked about the performance of contracts. That was the second area of contracts we were talking about, meaning we had started with the notion of formation, and then performance, and the flip side of performance being breach. We introduced the subject of remedies, and now we'll focus more on the money portion of the remedies, as well as defenses to an otherwise enforceable contract. So today we'll take up the question of damages and defenses under the CISG. Now, the CISG includes provisions for money damages, and those are available to both the buyer and the seller. Now, the party claiming the damages must prove, that party has the burden of proof to establish both the existence of damages and the amount of damages. And furthermore, that party, the aggrieved party, must establish that there's a causal relationship between the breach and the harm that was suffered. Now, again, as we discuss damages and the measure of damages available under the CISG, remember that the parties can always agree to damages within the contract itself. And in that case, the contract will apply. The contract measure of damages will supplant the CISG. The CISG, always remember, is a gap filler. It's designed to fill in the gaps in a contract, any terms that are not specifically recorded. So in this lecture, we're going to look at the damages available under the CISG, and then we're also going to look at the issue of defenses, meaning sometimes even when the elements of a contract are present, one of the parties may be able to avoid responsibility under the contract through the use of a defense, and we'll talk about that. But let's start with this notion of what are damages. What are damages? Well, the law defines damages as the money that's claimed by or is ordered to be paid to a person who has lost money, who has suffered an injury which has caused him to lose money. So damages are the compensation that's going to fix the injury, that is going to remedy the injury. Now, damages are going to equal the sum of money which a person who is wronged is entitled to receive from the wrongdoer as compensation for the wrong. In general, we call this in the law, we call this an expectation interest, meaning in a contract situation where there's been a breach of a contract, the aggrieved party, and that's the non-breaching party, we try and avoid the use of the terms innocent or guilty because those imply a morality aspect to contracts that's really not there. So we'll say the aggrieved party or the non-breaching party. That party is entitled to receive her expectation interest, what it is that she expected to receive out of the contract. Remember, I mentioned the concept that remedies for contracts are designed to put a person back in the same position as he would have been in had the breach never occurred. Now, there is the notion of liability as well. One cannot recover for a loss unless one first establishes liability. Now, the common law does not care about what was the reason for a contract breach. Under a common law approach, and this would apply in any court or tribunal that emphasized a common law approach, under the common law, the reason for the breach does not matter. It could be a very good reason. It could be a very bad reason. It doesn't matter. So if, for instance, a party fails to deliver goods on time, and the reason why is that one of the workers on the line suffered an injury and they had to shut down the line to take care of him, and it took a while to get back on their feet, and then they finally started producing the item again. And they missed a delivery. Well, that's a very good reason for missing a delivery, but it doesn't matter for damages calculation. It's the same as if the supplier decided not to ship to the original contracting party and sold it to someone else who was willing to pay more. That's a very bad reason, but it doesn't matter. The calculation of damages is the same. Now, under the CISG, under the civil law, liability, the reason for the breach matters a bit more. Under a civil law system, the court wants to know why the breach occurred, and that why can go into calculation of damages. That's the whole point of the not frisk period that we've discussed last time. Now, under the CISG, liability is a compromise, in essence, between the common law and the civil law, but leaning to the common law approach, which is to say that the reason why doesn't matter. Now, the CISG does respect the civil law notion of excuse, a legal excuse, and we will cover that when we talk about defenses. But understand that for our purposes, it does not matter why the breach occurred. The calculation of damages is the same. Now, there's one more item we want to discuss before we talk more about damages in detail, and that's the notion of anticipatory breach. Sometimes a party to a contract realizes that it will not be able to perform under the contract. Either as a seller, it will be unable to deliver the goods on time, or as a buyer, it may not have the money. It realizes that it will not have the money when the time comes for money to be paid. Now, in those situations where the party who's going to breach notifies the other party that it is going to breach, then that's what's called an anticipatory breach. And that is a fundamental breach. Now, in the event of an anticipatory breach, meaning a breach that occurs before there's an actual breach, the aggrieved party will have several options. First of all, they can suspend performance, meaning if you are a seller, you can hold off on the shipment of goods to the buyer who's announced that he cannot pay for them. If it is a buyer, if the seller is going to breach, the buyer can hold off on making any payments that it may otherwise be required to pay under the contract. Essentially, they can suspend their performance under the contract. Now, they also have a right to avoid performance. And remember, avoidance of a contract means rescission, putting the parties back in the position they would have been in had the contract never occurred. So, in the event of an anticipatory breach, the aggrieved party, the non-breaching party, can simply avoid the contract, meaning it was as if it never existed. And in the same way, if it's a contract that calls for installment payments over time, the buyer can refuse to pay further installment agreements. So those are all rights that are available in the event of an anticipatory breach.